Hello and welcome. This VPAL signature event is brought to you by Harvard's Office of the Vice Provost for Advances in Learning. I will now turn it over to our guest moderator for tonight, Ellen Popko, who is an instructional technologist here at VPAL. Ellen?
Thank you so much. My name is Ellen Popko. Today we are joined by Harvard Law professor Alexander Chen and Harvard Law School's LGBTQ plus advocacy clinic's clinical fellow, Maya Stata Reddy. Professor Chen is the founding director of the LGBTQ plus advocacy clinic at Harvard Law School, where he also teaches gender identity, sexual orientation, and the law. He is one of the nation's leading experts in LGBTQ plus civil rights. His work has been featured in the New York Times, The Economist, Bloomberg, Slate, Boston Globe, and many other media venues. Clinical fellow Maya Stita Reddy works on self-designed projects at the Harvard Law School's LGBTQ plus advocacy clinic to protect the rights of and promote the inclusion and well-being of LGBTQ plus student athletes through litigation, legislative advocacy, and policy advocacy in public education. Thank you for joining us tonight. Maya and Professor Chen, over to you.
Well, thanks for taking the time this evening, folks, to come here and learn a little bit about the topic of today's VPAL signature event, Leveling the Playing Field, Advocating for Trans Athletes' Rights under Title IX. And we were invited to, give a talk about some of the clinic's recent work in this area, especially responding to the Biden administration promulgating proposed regulations for Title IX, which is the federal law which prohibits discrimination on the basis of sex in educational programming, involving the rights of LGBT athletes. And I thought perhaps just to kick things off, Maya, maybe you could talk a little bit about your own background as a professional athlete and why sports inclusion is so important for the LGBTQ plus community, especially youth.
Yeah, absolutely. As I've told many people, I am very grateful to be in this space because I'm very passionate about gay sports law. And that kind of all stemmed from my journey playing golf. I've played golf since I was 3, so for many decades at this point. And I do also like to say I reverse retired. I played golf professionally and then went to law school and became a lawyer. But through my time playing golf professionally, I experienced a lot of racism, misogyny, and homophobia. And some of you might be saying, that's not surprising, it's golf. It's a very white, cis, straight, old man sport. But for me, I never saw it like that. For me, golf was just part of my life. It was where I got a lot of joy. I met so many friends. It was a great way to get out in nature at the very least, and also hit a golf ball very far with all of my might. So to be in a space professionally where none of those things mattered anymore, where all I was seen as was kind of like this outsider, this other that many people didn't believe belonged, was incredibly difficult. And the reason why I ended up stepping back from the sport, I think now I'm able to talk about it through this analytical lens because it's a little bit easier to do so. Because when I stepped back into it, it was incredibly painful to be ostracized from a sport and a space that I love and gave me so much. So I kind of channeled all of that anger and frustration and heartbreak into wanting to find ways to create a more inclusive world for LGBTQ folks within golf and then sports in general. And that kind of led me on this journey through working with incredible organizations like Athlete Ally, folks like Chris Mosier, who runs transathlete.com, which I'm sure we'll drop in the chat as an amazing resource, to law school, where I wanted to kind of up the ante on this advocacy and really dive into, legal advocacy for queer and trans kids in sports. And unfortunately, that's become an even more kind of glaring and pressing issue over the past 2 years, especially. I believe it was the past year that there were 500 bills issued against trans kids, both in gender affirming care and athletics. And so it has become even more important to protect kids in spaces like sports. And that's kind of went from golf to here. And I think that also shows the power of sports to kind of shape our paths and our lives. And all kids really deserve that opportunity to, as I did, retire reverse and then go to college after they play golf professionally. But that, again, not to be repetitive, is why I feel so lucky to be working at the clinic, where the clinic itself has been enthusiastic about supporting this project and supporting the work on protecting trans kids. Alex, I don't know if you want to speak a little bit more to that before we jump into kind of the meat of the conversation.
Thanks for that, Maya, and sharing your own kind of personal journey and why sports has been so important to you as a member of the LGBT community. Ellen, I think our co-moderator or moderator, I believe, has some prepared questions that might be good to jump into, since I understand this to be, a sort of Harvard-wide event where, maybe I think, Ellen, you're in a sort of better position to kind of like stand in the shoes of somebody who's not as deeply immersed in these issues as us, and we're happy to kind of answer your questions.
To a degree and stuff. I thank you very much for just your advocacy letter towards the Department of Education. And do you want to really just start off as to what one of the biggest themes throughout that is that there is such a focus on trans women's participation in athletics and kind of the regulation of perceived norms within this space of what those norms of are perceived norms of femininity and kind of regulating those. Why do we think that there is such an emphasis on that focus, and when trans identity is very inclusive and beyond just trans women?
I mean, that's a great question, and it's one with a very layered. There are many answers to that question, right? Of why is there such a focus on the idea that in society right now, transgender women or girls participating in women's or girls' sports would pose a threat to those women and girls, right? And so I think I can kind of kick it off with maybe some high level discussion, but Maya, please also feel free to kind of add in after I'm finished. So I think there's a couple of layers, right? So one layer is taking it away from sports itself. If you look at the history of American civil rights law, and you look at sort of what kinds of narratives have repeatedly been deployed, one of the sort of central themes that you can see is that this idea that advancing civil rights for a particular minority group could have a threat to the safety of especially white women and girls is a recurrent theme that you see throughout American history. So, for example, in 2015, when the case of Gavin Grimm went to the Supreme Court, which was the case of a transgender boy who was in high school and sought to use boys' restrooms, the NCAAP actually wrote an amicus brief on his behalf in that case, which said, we want the judges and the courts to know that we see a connection between this narrative that transgender people using bathrooms threatens non-transgender people, especially non-transgender women and girls, as having a historical parallel to the way that those types of narratives were used against the African-American community when it came to advocating for the end of Jim Crow, the end of segregation in places like restrooms, locker rooms, drinking fountains, swimming pools, and restaurants, and the way that those narratives are currently being used against the transgender community, right? That repeatedly in American history, we see this idea that there is this sort of fragility and this weakness that has to be protected of white women and girls. And the way to do that is to restrict the rights of other groups of people. And so I think, first of all, we kind of have to recognize that that's a historical pattern. And it's a historical pattern where there's a sort of fine line between the idea of protecting a group and also policing a group, or sort of, really putting a lot of rights and restrictions on the rights of a group, right? And so protecting women often turns into controlling women's bodies and scrutinizing women's bodies. And so that is one of the sort of just historical trends that we see in the sort of arguments that are being used against a sort of the inclusion of different groups. And there's another example that I can point to from the 1970s, right, where there was a major battle over whether we were going to enshrine the Equal Rights Amendment into the United States Constitution, which would have said, as a sort of textual matter, that the Constitution protected against unequal treatment of the sexes. And that fell just a few states short of ratification within the sort of prescribed period that the Constitution has for having, an overwhelming majority of the states sign on. And one of the key arguments in the 1970s that was used to defeat the Equal Rights Amendment was the one that was used by Phyllis Schlafly, a prominent conservative female activist, and the Stop ERA movement. And that was the argument that enshrining equal rights would mean the end of sex-separated bathrooms. And there only being unisex bathrooms, and that would pose a threat to the physical safety and well-being of women. So we see these kinds of arguments used time and time again when it comes to we can't have civil rights protections that sort of bar a particular kind of discrimination, because if we do, the result will be the end of these types of separations in these historically separated spaces, separated on particular identity trait. And the result of that is going to be that there's going to be harm to a particularly vulnerable part of our society. So I think we kind of have to understand that context first to understand why is there oftentimes this sort of concern around what will be the consequence of saying that everyone is equal before the law. And then we can kind of look also at the political context of the time that we are in now to see sort of that there's a politicization going on as well of the transgender issue, which really stems from sort of wider political and cultural currents in our society and sort of what is sort of coming at the forefront of the culture wars for reasons that are not necessarily to do with either law or policy. Because as, I think Maya, you can talk a little bit about, the reality is that actually transgender people have participated in sports at the highest level for at least half a century. And there have been policies promulgated at the international level for how to account for, transgender sports participation. And yet here is the time at which this has become a sort of, nation-wide issue in which there's a lot of press focus and attention, right? And so I think we also kind of have to sometimes think a little bit about that political context to understand, why is there kind of an intense focus on a particular aspect of policy at the present time. Maya, I don't know if you want to kind of talk a little bit more specifically about the sports context.
Yeah, and I think like Alex was saying about kind of like the background of protecting white women specifically, and this tradition that the United States, and we could probably see this in other Western countries as well, but that directly kind of creates this idea of, the white supremacist idea of femininity and the necessity of protecting that idea. And so when we're looking at sports, like we got to look back at when were women actually allowed to play sports in a meaningful way. And I don't know the exact date there, but a lot of the pushback towards women playing sports was the fact that it makes them less feminine, and so less delicate, less kind of adhering to this white supremacist standard of femininity. So there is this long tradition in sports of viewing women in this way of kind of skepticism, like if a woman kind of deviates from this standard of femininity, and they look like athletes, as an athlete's body should look like in order to play a sport, but is deemed kind of more masculine, then they're going to be the subject of scrutiny. And I think we're looking towards the IOC for a more recent example with Caster Semenya, which many folks may have heard of. She is I'm not sure if she's South African, but she is from the African continent, female Olympic runner, who was targeted by the International Olympic Committee because she won a race, and she also did not look, like this delicate feminine woman, because in fact, she looked like an athlete and she was Black. Caster was subject to many rounds of sex verification testing, which means that her chromosomes were examined to ensure that she indeed was a woman. And I'm not sure any other testing that she encountered, but I do know that the chromosomal testing was like a big one. There is also the Indian runner, Duti Chand, who also a woman of color who has the body of an athlete, was brought under scrutiny because she doesn't match that standard of femininity. And the rhetoric around this was that these two runners, because they are not this kind of like a delicate image of a woman, are threatening women in the sport. And so therefore they must be subject to all of this testing, and we got to make sure that they're actually women, for, purposes of making sure they don't kind of take up space from other female athletes. And I think what's really interesting about these two cases is, as far as I know, neither one of them identify as trans or non-binary. And so in that sense, two women who are not trans or non-binary are being viewed as a threat to women's sports because they don't adhere to this idea of femininity. And this kind of sex testing, this sex kind of like scrutiny, isn't new with Castor and Duthie. It's happened for ages with the International Olympic Committee. There was a Spanish runner, who, a few decades ago, who was subject to sex verification testing because she also was viewed as a threat to this kind of idea of femininity. And, this sex, and I'm sure I'll probably get into this because I do think that it's a very important aspect of this kind of policing of gender, but the sex verification testing is something that the International Olympic Committee has engaged in for decades as well, since kind of like the inception of the Olympics. And all of that is because of this kind of apprehension, anxiety that a female athlete would not uphold white standards of femininity, and in fact kind of like bring all of this crumbling down and mess with, fragile masculinity. But that's kind of like the background. And I do think that like this historical idea of what femininity is matches or maps on directly to sports and directly onto, like I mentioned, this anxiety that if a woman is more physically active, just in general, then they are going to pose a threat to, masculinity or what quote unquote femininity is supposed to be.
Yeah, and I think I'll just add, as somebody who was not as immersed, in sports policy before, Maya joined our clinic, and we've kind of been digging into these issues, but is more versed in the history of anti-discrimination law and civil rights. That I think one thing that I've really learned from this advocacy that we've done is really to think about that there's a lot of nuance here, right? There's a lot of nuance in there being perhaps, for example, a difference between sort of what it makes sense for a government or a state to regulate, especially when they don't necessarily know a lot about these kinds of nuances, versus what a sports governance body might decide, right? It might, in the end, be something where it makes sense as a sort of societal or policy matter that every sport would sort of understand the nuances of, what is the impact of different kinds of, biological features in sort of what is the impact on the result of a competition. But that is completely separate then. Does it make sense for a state like Alabama or Arkansas to legislate that every single, person in the state is going to be under this particular regime when it comes to sports in that state, and we are going to try to enforce that by sort of like testing or verifying the sex of young people across the state, right? And I think we can sort of separate out sort of what government bodies could do for sports policy, which is not really a legal matter, right? It's a policy matter, from what is it that our governments should be doing at the federal and the state level. And I also think that we can separate out different tiers of competition, right? So what policies might make sense at the international level to ensure, who are the people who get to compete, to get named the best person in the world at any given moment to do something, versus what are the goals that we are trying to achieve when we have young people participate in sports across America, right? And the vast majority of sports that are being covered by regulations like Title IX, we're talking about the K through 12 context. We're talking about public education, and we're talking about what kinds of sports opportunities are kids going to get access to. And the vast majority of these kids are not going to be professional athletes. They're not even going to be collegiate athletes. They're not in the running for competitive college scholarships. They are going to be at school on the playground. And what is it that you are trying to achieve by bringing those kids to PE in the first place? Right. And, a lot of the things that educators and people like Maya talk about are, well, we want to teach things like that it's good to move your bodies. It's good to get off those screens. It's good to learn teamwork. It's good to learn how to be a gracious loser. It's good to learn how to cooperate with other people. And so these are the kinds of values that, PE programs are often trying to impart on their kids. And the real question is, when you have this type of level of scrutiny, are kids who are not just transgender identified, but also gender nonconforming, just not following gender stereotypes, they are the ones who get more teased and more harassed on the schoolyard already. They are already at elevated risks of bullying and harassment. And are these types of laws getting passed and these types of regulatory regimes being enacted going to exacerbate the feelings of exclusion or anxiety that children already have at school? And are they going to allow for opportunities for more invasive scrutiny of children's bodies, right? So in Florida, for example, there was a huge public outcry because the transgender sports bill they tried to pass would have included a provision that essentially allowed it to be the case that, the menstrual cycles of teenage girls in the state would be tracked to try to determine which of them are transgender or not. And, you might think that sounds completely absurd, but really, if the thing is, there's no public data where you can go to some database and find out this person is transgender, this person is cisgender, right? If a kid enrolls into your school district and they present a certain way and they have certain kinds of legal documents, you don't necessarily have any other typical way of going in and trying to really find out what kind of body they have. And so if you're going to try to police that, how are you going to do it? Are you going to mandate a statewide system where every single kid is going to get sort of subject to certain kinds of physical verification or scrutiny? That opens up the opportunity for abuse, for humiliation, for harassment, for stigmatization of young girls who already feel like their bodies are really being overly scrutinized. Or is it going to be selective? We're not going to test anybody unless somebody raises an issue. But then who gets that issue raised against them? Typically, it's going to be kids who don't really fall within those stereotypes. And as we pointed out in our comment, there's a lot of data to show that that's going to have a racial disparity impact as well, because girls who are from African-American, Latino, and other kinds of backgrounds are more likely to be perceived as not feminine, right? And so they are more likely to going to be the kids that are going to get that kind of scrutiny from authority figures and from peers who are saying, hey, these kids don't fit into the standards, right? And so I think that's really what we tried to focus on for our regulatory comment is saying, look, I think when we are thinking about using the power of the government in these areas, we have to be really thoughtful about what is the policy impact on the ground, not just sort of if we were sitting in an abstract vacuum, what is the intellectual solution to a situation, but what happens when you use the tools of the law and the tools of government in a particular policy area, and have we thought through all of the implications?
That's excellent. I'd love to kind of pick back up on like what does that look like on the ground, and what are ways to make it more inclusive. There was an example in your letter of a student who was in a volleyball program and on a volleyball team within one university, at least all on the paper as far as like regulations allowed for this trans athlete to participate on a women's team. They still ran into lots of issues related to acceptance. And even though that it was still okay on paperwork, there was still a climate around them that did not support them and that they were challenged constantly for this. After transferring to another school, they thrived in a rowing program. And so I'm curious as to what are some of the things that we to echo one of the questions in the QA here, to like that we could be thinking about on more of a local level that may help drive policy and be able to actually create more inclusive spaces in those areas.
Yeah, I think that's a really good question, or something really important to think about, because as Alex was mentioning, this isn't a strictly legal issue. Like when we're looking at, the folks that are promulgating these rules in sports, they're these national governing bodies, and, they're not, for the most part, lawyers. So I think to that end, it's really important to think about this kind of like what is even happening to the kids on the ground who want to play? And we don't always think about that. We think, like, tomorrow, I believe there is a hearing in the House about the Protect Women's Sports Act. And we hear things like that. We hear about all these different acts and bills. And we're like, yeah, obviously we're against those. But the thing is even if we kind of beat these bills, their effects are still lingering. There are kids on the ground who are hearing that so many people around them, including lawmakers, don't want them to belong or to play sports. I mean, at the end of the day, sports are kind of silly, right? Like, you just want to go play a game, you like throw a ball around. Like, it's not necessarily the most serious thing in the world. It's all about play. And yet you have all of these lawmakers and these administrators saying, you can't play because you have a certain identity. And so I think that, like, the first thing to do is really to focus on education, because the majority of these people don't really understand, one, Title IX and its effect on athletics. And as a side note, we at the clinic wrote a toolkit that should be in the chat somewhere that kind of goes into Title IX in athletics. But also, these lawmakers, many of them may have not met a trans person. So they may not, let alone understand gender identity, but they may be, perceiving trans folks in this really abstract, politicized way. And so I think that it's really important to kind of educate both on this kind of legal aspect with Title IX, but also in this humanizing way. Alex and I were recently on a panel with at the National American Pacific Bar Association about this very issue. And we're really lucky to have two trans athletes on the panel, Skylar Baylor, who is a Harvard College alum, and Sarah Rose Trans, who is a skier, now a teacher in Vermont. And the two of them really, like, it's really amazing to hear the experiences of two athletes who have had to kind of go weather this climate and weather these kind of really awful comments and these efforts to prevent them from playing sports. Sarah, in fact, testified at the Vermont legislature about kind of like inclusion in sports. And she actually is one of the featured folks in this brilliant documentary called Changing the Game about trans athletes in sports, which, on the topic of humanizing this issue, that's a really incredible place to start. Because when you get to meet folks that are constantly positioned as other in this really abstract way, villainizing them, especially when it comes to kids, once you get to meet them, like for folks who haven't met them, then it's harder to be as cruel as they have been. Or at least I'm hoping that for the most part, it would be harder for them to be cruel. Although I'm not sure about folks like George Santos. We don't know where his brain is. But, like when we're thinking kind of all of that to say, when we're thinking about on the ground work that we can do, it is humanizing, it's educating, and it's having these conversations that are, uplifting trans folks. It's about kind of being curious, like many of you are in the chat. It's, wanting to interact instead of shying away and just kind of listening to what the other side is saying. Because they're saying a lot. And they're probably going to be saying even more with this election year coming out. But the way I see you fight back against that is educating yourself and listening to the voices of trans kids. Oh, and as a side note, some resources in addition to Changing the Game, I would highly suggest looking at Chris Mosier, who is one of the first trans folks to make the US Olympic team. He does a lot of incredible work in advocacy with transathlete.com. Skylar Baylor, as Alex mentioned earlier, is a really powerful educator and does a lot of talks and programming around this issue. And, like I said, changing the game. Also really brilliant. But those are some folks that I think should absolutely look to for more information, because they're folks who have experience. It's trans voices speaking about this issue. And as a cis person myself, I can speak to wanting to uplift these voices and knowing that it's really, really important to uplift the voices of folks who are experiencing these spaces in this particular way, knowing that it really sucks in varying degrees when you are a person of a marginalized identity that is being villainized and prevented from taking part in the sport.
Excellent. We have a question here. Are there any examples of international sporting organizations that have inclusive policies that seem to reasonably balance these complex issues? What can be learned and used as a model from any of those, if any?
On the international level, no.
If it's not on the international, if you can think of one, that would be wonderful.
So I'll quickly say, because the NCAA is looking towards the International Olympic Committee's policies to kind of guide their policies. But the IOC recently released, I believe it was a few years ago, a framework on trans inclusion. And essentially they're saying, like, you have to respect integrity, privacy, and a few other points. But while you would say, like, this sounds great, in spirit, it is great. But in practice, what it really does is hunt back the process of determining a trans inclusive policy to individual governing bodies of sports. So they say, hey, don't be really horrible to trans folks, but also you can decide whatever you want to do. And there's a lot of loopholes there, as you can imagine. Here, again, off the top of my head, I'm not completely well versed in the specifics of American national governing bodies of sports, their policies, but I know very recently the swimming national body changed their policies to be more restrictive in response to University of Pennsylvania swimmer Leah Thompson's incredible showing at the Division I national championships. And so what the national governing body did was increase increase the barrier to overcome when it comes to testosterone levels. And the kind of like timeline in which an athlete would have to show that they meet this kind of limit. And this was directly in response to a trans athlete. There are some other bodies that have done similar things. But I think also another notable thing is that the NCAA doesn't have its own policy. Similar to the IOC, they were like, you know what, we're just going to leave it up to the national governing bodies of sports. And if you're playing golf, right, like the NCAA doesn't have a specific policy for golf. You have to look to the USGA's policy. Same thing with swimming. And so, Ellen, I think you mentioned earlier, like when we're speaking prior to this, like about the hodgepodge nature of all of these policies and laws. Mm-hmm. I think that's a really great example of that is nobody knows what they're doing. They're kind of making it up on the fly, mostly in response to, as we were talking about earlier, this perceived threat to femininity to women.
Yeah, I mean, my understanding of the situation is that there's been a little bit of a backslide on international sports policy where, in the middle of the 2010s, there was, both at the NCAA level and the IOC level, a sort of set of rules that applied to like all of the athletes where it said, if you have, been on, for transgender women, testosterone suppression for, X number of, months or years, and you can show that your, hormonal range is within, a range that is typical for cisgender or non-transgender women, then you're going to be allowed to compete, right? And I think the political backlash to that we're seeing right now internationally and domestically has caused a lot of these governing policies bodies to backpedal and to sort of say, let's go back to a more sort of, sport by sport analysis. But the issue is that, there's very little data on a lot of these areas, and they don't necessarily have the information they want to have in order to provide a more nuanced or targeted policy sport by sport, right? Because the reality is that, whether or not somebody experiencing some degree of testosterone exposure is going to impact positively your ability to play a particular sport really depends on the sport. And whether or not that's a competitive issue really depends on, whether are we talking about an individual sport? Are we talking about a team sport? Are we talking about something like shooting or pool, for example, where, there are actually some arguments that women have advantages over men in the way that they perform? Are we talking about a contact sport, right? So I think there's a bunch of different factors that play into it. And I think right now we're in a sort of a little bit of a sort of unresolved state at the international level because, we're in flux. I think that, though, however, what I might be helpful to point out is that we can point to better examples of state level policies that are not about international competition or even national level competition, but more about just sort of school sports participation. And so, for example, California in several years ago became the first state to pass a law that said that, not only are you prohibited from discriminating against children on the basis of gender identity and education as a whole, but that also includes the way that they are integrated into school sports programming. And on the ground, there's a lot of ways in which you can have co-ed teams, you can have kids playing individual sports, you can have kids involved in practice squads who are transgender, even if they are not allowed to compete at a sort of state level or a national level because of other regulations that might implicate that. So there's, I think, better examples at the state level of schools and educators who are really trying to be thoughtful about how to be as inclusive as possible to all kids and get them on the field and playing and moving their bodies as much as possible, while kind of trying to skirt away from, getting sort of jammed up with some of what's going on at the national level. And I think one question that I see from the live stream is really around sort of, what is sort of the legal landscape going to turn into over time, right? And so I think, the short version, and it's a big, complicated question, but I think the short version is that, there have been a number of pieces of litigation that have been winding their way through the federal courts. Some of them have been sort of affirmative challenges to states that have banned participation from transgender women and girls in women's sports, or sometimes transgender people in sports consistent with their gender identity. Some of them only target transgender girls and women, and some of them target all transgender people. And then there also have been some cases which have been where sort of people who are not transgender have challenged more inclusive policies that more liberal jurisdictions have passed that allow for transgender kids to participate in sports consistent with their gender identity. That is kind of in parallel with a number of other court challenges that have recently been wending their way through the federal courts, which are involving other issues, including transgender bathroom usage, and also the issue of gender affirming medical care for transgender youth, right? And so, the sort of the backdrop is that in 2020, the Supreme Court in the Bostock versus Clayton County decision ruled that for the purposes of Title VII, which is the federal law that bars employment discrimination, when that law said you can't discriminate on the basis of sex, the Supreme Court says, as a matter of textual interpretation, sex encompasses gender identity and sexual orientation. And that was a purely formal legal analysis where they said analytically, that's true because it's impossible to extricate an interpretation of what sex is from gender identity and sexual orientation. You can't actually explain what sexual orientation and gender identity are without reference to sex. So they're inextricably intertwined concepts. And anytime you have that bar against sex discrimination, it includes sexual orientation and gender identity discrimination. Now, that then led to this question of, okay, well, what does that mean? Sure, that definitely means you can't fire a transgender person or a gay person. You can't refuse to hire them. You can't refuse to promote them simply on the basis of that status. But what does it mean for these other questions of how do you treat somebody in the workplace? What about dress codes? Does it mean that a transgender person has to be allowed to dress according to their gender identity if you have a sex-separated dress code? Where are people going to go to the bathroom? Where are people going to go to the locker room? And that section of questions, which is not like purely about refusal to hire or refusal to enroll a student, but about what are their sort of workplace conditions, or by analogy in the school context, what are their school place conditions? That's the unresolved legal question. And that's the question that in one version or another is likely to go up to the Supreme Court in the next 2 to 5 years. And in fact, the ACLU just petitioned for a writ of certiorari, which is Supreme Court review, in a case involving a ban on transgender gender affirming care for minors that is coming out of the Sixth Circuit. And so those cases being taken up by the Supreme Court, and then those questions being addressed, is going to have a major impact on what the constitutional and the statutory landscape might be for whether or not it's even cognizable to raise a claim to say that any of these policies being passed by the state governments are constitutional or not. And, that relates to another question that I see in the Q&A about sort of this idea of like, well, what are the arguments that are going to be relevant to the Supreme Court to entertain? And one of the key questions is going to be, when you say something is like sex discrimination, what does that mean? Or if you say something is a violation of equal protection, what does that mean, right? What conception of equality do we have? And how are we going to interpret it? And I think what I'll say about that is, without getting all the way into the nitty-gritty of the legal analysis, we are currently before a Supreme Court and a federal judiciary in general, which has become much more conservative and which has shown a historical willingness to overturn decades of precedent involving our understanding of the scope of equal protection and non-discrimination law in America. And two very big examples of this that you're probably aware of. One is that their decision in the Dobbs case to overturn the fundamental right to abortion in Roe v. Wade. And in the Students for Fair Admissions case last year, where Harvard's admission policies were among those challenged, to rule that it was a violation of equal protection to engage in affirmative action programs. Both of those decisions reflect a willingness to depart from longstanding interpretive practice when it comes to both constitutional and statutory guarantees, to read protections more narrowly, and to look away from sort of a wider conception of equality that will have an impact on how society operates, right? And so in the specific example of sex discrimination, in the gender affirming care case, the Supreme Court said, well, it's not a violation of sex discrimination protections to treat transgender kids differently than cisgender kids when it comes to access to things like, for example, puberty suppression hormones that are used both for transgender teens, but also for non-transgender teens who are going through conditions like, precocious puberty, right? We're not going to see it as a problem because all transgender people are barred from accessing something and all cisgender people have access to it. And so we don't see there being a problem if it's not a distinction between what boys are being given access to and what girls are being given access to, right? So it's this kind of like more narrow conception of what inequality means. And people who oppose that argue, well, the same arguments were used when it came to why preventing people from marrying when they were of the same sex was a violation of, anti-discrimination laws. People said, well, everybody is being treated the same because everybody can marry people of the opposite sex and nobody can marry people of the same sex. So it's not about sexual orientation discrimination. Everybody is being treated the same. And similar arguments were used to oppose, for example, Loving v. Virginia, which was the Supreme Court case which ended anti-miscegenation laws, where there were those who said, well, it's not racial discrimination because everyone's being treated the same. Everyone can only marry people of the same race. And everybody can't marry people of different races. So white people and black people are being treated the same. And in all of those other cases, courts came to recognize that you can do a very mechanistic analysis of which that's true, but what you're missing is what is the impact on society when you have certain kinds of divisions or separations that we are going to sustain and we're going to say this is separate but equal, and it is actually equal. In practice, it's not. In practice, it has a differential impact on certain groups of people. In practice, it has an impact on how everybody in society behaves and on the ways in which it is okay to separate people on the basis of these immutable characteristics. So unfortunately, though, the Supreme Court and our courts in general have not always gotten it right. We did not. Before we had, the civil rights movement, we had Plessy v. Ferguson. Before we had the Civil War, we had Dred Scott, right? And so we've had numerous occasions. Before we had Obergefell v. Hodges, we had Bowers v. Hardwick, where the Supreme Court upheld a ban on sodomy. And so before we had, strict scrutiny of, racial discrimination, we had Korematsu versus the United States, where the Supreme Court upheld Japanese internment. So we've had numerous periods of time in American history where we could not look to the courts and have the courts say, we are going to interpret the constitutional provisions and the laws that our legislators have passed in the way that will most advance people being treated equally in our society. Unfortunately, I think that we're entering into a period of time in which that is extremely likely to happen when it comes to some of these transgender rights cases. And so the reality is going to be that there is going to be state-sanctioned discrimination that has passed, and it will stand in some jurisdictions in at least some of these contexts. And I think sports is very likely going to be one of them. And so really, as lawyers and as educators who are thinking about how are we training the next generation of students, how are we helping them think about what their role is when they're going into this world with these legal tools, what is that role? And how can we think about a broader conception of what it is to be a lawyer beyond just litigating cases before the Supreme Court or upper appellate courts, and thinking about how can we use these tools of legal analysis in order to understand how we can intervene when it comes to agency policies, regulatory policies, public education, laws that are being passed in jurisdictions where people are favorable towards protections for LGBT people, and how do we work with educators and non-legal entities as well in making policy. And so I think a lot of the work is going to have to shift in that direction, because sometimes you go through a period of time in which that is the environment that we're in terms of the dominant interpretive frameworks that are being adopted by our federal courts. And so then you have to look at other ways of making change if you care about these issues and you're a lawyer.
You sort of touched on this, but wanted to also just kind of pick up on another question in the QA here is what can be learned about legal social issues that also involve balancing complex civil rights and complex scientific issues over time and stuff. Especially just I'll footnote the complex scientific issues more that there's sort of a complex misunderstanding of scientific issues that is out there. And just curious as to what other sort of civil rights struggles may also encounter this.
So that's a great question. I think that what I'll say is, so I'll maybe separate it out, right? So on the scientific piece, I do think that it is really important that we separate out, we avoid enshrining scientific understandings that could become outdated into our legal and regulatory frameworks, right? And another good example of this is homosexuality. So homosexuality used to be considered a mental disorder, right? It was a mental health condition that was actually in the American Psychological Association's diagnostic and statistical manuals of disorders. And, if we imagine a world in which Congress had passed laws defining what homosexuality is or sexual orientation is, and relying on those then current medical understandings, we really could have ended up in a place where the law was really behind how, the medical community evolved over time in its understanding of what sexual orientation is. I think we're very much in danger of doing that when it comes to gender identity and transgender people. Lawmakers right now are very willing to enshrine certain kinds of statements about sort of the nature of, for example, what they call sometimes biological sex or biological gender that we already know are inconsistent with the best scientific or medical understandings of sex and gender, right? And if you talk to medical experts, which we frequently have in our cases about these issues, they'll say, well, there's 7, 9, 13, 20 indicia of sex. There are 2.7% of the population have disorders of sexual development, so-called, which are ways in which those markers don't just line up 100% one way or the other. And actually, the scientific reality is that sex is much more nuanced, is much more of a spectrum. But we don't necessarily have that understanding as a matter of popular culture. And now legislators are writing these bills, asserting things that we already know are scientifically inaccurate and are likely to become more and more scientifically inaccurate over time, right? And so I think that, one concern really is from this situation of we don't want to have the law enshrining these kinds of understandings in a way that kind of prevents medical and scientific research and development from occurring, and sort of non-legal policymakers from making decisions that are much easier to change than decisions that have been passed by legislature or when you promulgate rules through an agency, right? And so I think that is something that we really are concerned about here. And then I think that in terms of, quote unquote, the idea of competing civil rights, I think it's really important. Those other examples that I raised earlier in this talk really are good examples of when actually the real lesson is are those rights actually competing? Or is that the narrative that is used to set different groups against each other because they perceive the rights to be competing when in fact they are not, right? And so was it true that there was in fact a threat to the safety of white women and girls from integration of African Americans at the end of the Jim Crow period? Or was that something which actually was not really particularly based in any type of empirical evidence or fact, but was instead the sort of result of ignorance or bigotry or suppositions that were not in fact true? And here, in the case of transgender sports participation or transgender bathroom participation, right, the sort of striking thing to me is there's a huge distance between the rhetoric, which would kind of imply that there are lots and lots of cases in which there is some kind of threat that is being posed to health and safety from integration, and the reality on the ground, which is that there really has not been. Right. In the bathroom context, for example, we have amicus briefs from school administrators in 17 plus states saying we've actually been integrating transgender students into our schools for quite some time now. And in fact, we've experienced very few problems when it comes to the actual practicalities of it. And to the extent that we're concerned about things like bathroom usage, well, there are already laws and regulations saying that people should not be attacking, accosting, or harassing other people in bathrooms, right? Or when it comes to sports participation, what kind of sports is it? Is there really some kind of risk or not? I think actually we have ways of figuring these things out already, but they can only be addressed if there isn't this sort of like conviction that there must be something to the idea that there's a competition between those rights, right? And I think that actually we often end up talking to educators about how, as a matter of sort of just sound pedagogy, teachers know how to sort of accommodate students when they have special needs. They know how to address when students sort of, are having conflict with other students, but are they applying the tools that they already have? Or is there something about the situation which is causing them to not be able to apply those tools that they already have to come to a good policy solution, right? And so I really think that those are some of the lessons that I would take from looking at parallels to this present situation that we're in. And also to say that, we should be really aware of when those kinds of pernicious stereotypes are used. Right now, there's also a huge sort of argument going on around curricular content for schools, right, which involves both disputes over the teaching of so-called critical race theory in schools, but also the teaching of, role models or, historical examples from the LGBT community in things like the Don't Say Gay bill laws in Florida. And one of the most sort of common tropes that are being used there is this idea that it's somehow inappropriate for children to be learning concepts around sexual orientation or gender identity. But that trope really plays upon, these decades-long stereotypes that gay people should not be around children because there's something fundamentally inappropriate about having a sexual orientation which is not heterosexual or having a gender identity which is not cisgender, right? And so, in the 90s, those types of canards led to repeated purges of gay school teachers in a way that today we really, generally speaking, don't think it's inappropriate to just be a gay teacher. But for decades, in fact, that was in fact true, right? And that gay people often got fired from positions that involved being around children because of this pernicious stereotype that, gay people were more likely to engage in things like pedophilia. That really has absolutely no basis in scientific fact, but again, kind of plays upon these sort of perennial fears of threat to women and children. So I just think that one of the biggest lessons is that when that particular argument is being deployed, we should really be thoughtful about, is in fact that something that has a basis in fact, or are we falling prey to some of the same tropes over and over again for why different minority groups should not be protected within American society?
Kind of just start wrapping things up here and stuff. I'd love to know, how did the clinic at Harvard Law School come to be involved in this issue?
I'll say that we both look to, what kinds of legal issues are good teaching opportunities for our students, right? So the way that our clinic works is that Harvard Law students can enroll to be clinical student attorneys and work on projects that involve either litigation or policy that implicate LGBT rights. And we look for issues that are good teaching opportunities, right? And this is a good teaching opportunity for us because it is an opportunity to engage in some of this really balanced and nuanced and detailed thinking around understanding complex issues, what should, organization's position be on those issues, analyzing the way that law and policy intersect. And so, for us, I think this type of area, which is very cutting edge, is also a really great opportunity for our really smart and talented students to cut their teeth and to be involved in things like drafting, legal research, also interacting with partner organizations. We, ended up sending in that regulatory comment as a collaboration also with Athlete Ally and the National Women's Law Center we worked with on the toolkit, and the Athlete Ally we worked with on the comment. It's an opportunity for them to work with partner organizations. So those are some of the criteria we think about. But part of it is also, simply, what personnel do we have in the clinic and what areas of expertise do they have, right? Because we really want the students to be working on these issues with people who have, subject matter expertise and really a special insight into what it takes to really, be at the forefront of some issues. And so I think also in having Maya join us as a clinical fellow this year, we felt like we also had some of the, insight into what it meant meant to be a player, relationships with sporting bodies, and relationships with other advocacy organizations in the sports space that meant that our not only would we feel confident that we had the ability to really formulate a thoughtful policy response, but also the students would be able to get exposed to that.
Maybe losing you just a little bit there, Professor Chen. Maya, do you have anything else that you would like to add about your experience within the clinic?
I have nothing but good things to say. It's been an incredible way to kind of marry my personal experience playing sports and then in the sports advocacy space with a really deep kind of learning about how does the policy like regulatory framework work, what does litigation look like, how do we kind of interact with legislation. And I think on a personal level, it's been amazing to get that experience and learn from folks like Alex. I was able to sit in on one of his classes, and I think it was truly one of the best kind of educational experiences of my legal career. And so to kind of like have all of that, to learn from people who've had like this extensive experience, to marry that with my personal experience, I think was an amazing experience. And I would be remiss to not point out that us and our sports project is one of very few active sports projects in a legal kind of organization in the country. National Center for Lesbian Rights has a sports project. However, it has not been as active lately. As you can imagine, many of these larger LGBTQ impact lit organizations are inundated with a lot of really horrible issues, right? And so it is difficult for some of them to dedicate the personnel to go after the sports issues. So I think it's really incredible to be able to do that, not just at the clinic with such amazing kind of personnel, but also one that is supported by Harvard. And it's never a bad thing to have the Harvard name on an issue advocating for marginalized folks.
Yeah, and if I'm back and people can hear me again, I guess I'll add just one final response to a question that I saw, which was about form. So in the notice of proposed rulemaking that the Biden administration made around Title IX, what did we support and what did we oppose? Right. So you can look at the link that we dropped in the chat to get the whole comment. But the short version is, what we supported was that they did come out and say, in general, we adhere to an interpretation of Title IX where discrimination against transgender kids is discrimination on the basis of sex, and we do not support barring transgender kids categorically from participating in sports consistent with their gender identity. The part that we really critiqued was that they didn't necessarily then specifically delineate what types of ways of trying to enforce sex separation would have certain kinds of impacts that school districts should be mindful of, right? Because one of the biggest things that, this regulation, once it comes out, will immediately be challenged in court and will spend years being challenged in court before, if it ever sees the light of day as an adopted or promulgated regulation. And in the meantime, a lot of the impact is going to be on school districts are going to be looking at the Department of Education, looking at this regulation to understand how should we be thinking about crafting policy. And it is really valuable when agencies say, you should be really thoughtful about when you try to do it this way or that way. Because if you end up giving it a blanket policy, think about the privacy interests of the students. If you end up saying, hey, we're just going to deal with it as it comes up, are you going to end up in a situation in which students are going to feel targeted by the way that you're trying to enforce regulatory policy? So we really wanted them to be more thoughtful about the structural impact that would have, and that it would really have, that were very predictable based on what we've already seen with the history of policing of sports. And so that was really the perspective we were trying to bring that the students really helped Maya put together.
Well, with that, I think we're actually at time. I really want to thank both of you for just a fantastically engaging conversation here. And this really just covers so many different aspects of, regulation, social participation, and advocacy and stuff. I also just greatly applaud the Harvard Law School's clinical model of being able to actually get involved in practice of law. And this is an excellent example of that type of work. And so, yeah, join me in thanking both Professor Chen and Maya for a really engaging evening. I greatly appreciate it.
Thank you, Ellen. Thank you, Maya and Professor Chen. And thank you all for joining us tonight. We hope you'll join us for more signature events soon. Information on upcoming events, as well as recordings of past ones, can be found at vpal.harvard.edu/vpal events. Thank you. Good night.